Welcome back to KTN News Diary. Now, earlier this morning, our team at Spice FM did have an intensive conversation regarding review of penal and criminal procedure codes to align with the 2010 Constitution. How best can that be done? And of course, they hosted Lady Justice Grace Ngenye, who is the chairperson at NCAJ Committee on Criminal Justice Reforms. And in studio was also Wakili Edward Muriu, who is the member of Parliament Gatanga and member of Justice and Legal Affairs Committee. Let's listen into what they had to say.
We've met again. Happily that I'm meeting her again in my committee of Justice and Legal Committee. Now this time not as a magistrate, not as a judge, but a judge of the Court of Appeal. Am I right? So we need to be very careful, Latif, when you say judge of the High Court. That's an understatement. It's judge of the Court of Appeal.
Sincere apologies. J.A.
I'm also very proud that I am the one who received the proposed amendments to modernize our penal code on behalf of the Justice and Legal Committee of Parliament. And maybe also, I'm also very proud that for the first time in the history of the Republic of Kenya, the consumers of the law, or the people who operationalize the law, have taken upon themselves to bring up proposals to amend the law to suit the situation. That is amazing. It's an unprecedented. It has never happened before. You may find that in the old constitution, it's only Attorney General who had the power to bring new laws. Today, under our new constitution, everybody, either individual institutions, they have the capacity now to change the law, propose the law, bring them before Parliament. And I'm so proud that the old piece of relic, the old law, that's the penal code, has been able to bring an attention. And the beauty about it is that it's an omnibus. There have been small amendments here and there, but I think these are omnibus repealing of the penal code.
We'll get into the details shortly. Thank you very much, Wakili.
Yeah, thank you so much.
To welcome you to the conversation, and yes, Judge of the Court of Appeal. I'd seen that earlier and then saw something else and it totally confused me. Sincere apologies, Judge.
Yeah, it is all right.
To welcome you to the conversation, CT has the day's proverb. He always has a proverb, and every week he picks one country where he goes and gathers some interesting proverbs. This week's proverbs are?
From Tanzania. This, for the last 2 weeks, well, we were first in Kenya, then we went to Uganda, now in Tanzania. So we dedicated these 3 weeks to the 3 East African countries. The bitterness of a son is known by the parents.
The bitterness of a son is known by the parents. That's the malady.
Yes.
What do you make of this proverb? What's your interpretation?
Thank you very much, Latif. But even before I get into that, you know, Mheshimiwa knows me too personally, and so he can speak so much about me. And it is true, our journey began quite far. In the 90s, Latif, you must be much younger, I know.
Well, in the 90s when you were doing what you were doing, I was doing something else.
Exactly. And we have come this far. Yeah, but before we get into that, receive a kind greetings from my boss, the Honorable the Chief Justice. In fact, I'm here with her blessings, and we engaged them, the JLAC members. And as he says, it is very true that he's the person who received the bills. In fact, I have copies of our bowed proposed amendment bills. What is interesting is that these statutes, the Penal Code and the CPC, are as old as about 70 years. And the last time there was a holistic amendment to them was about 1930. So for us as a committee, NCCJR, in short, and the auspices of the NCAJ, are quite honored that we have undertaken this journey to ensure that the 2 statutes are holistically amended. And as Mheshimiwa says, of course, there have been piecemeal bills that go to Parliament intending to amend and have amended piecemeal provisions of the two statutes, and therefore ourselves being charged to overhaul the entire criminal justice system in Kenya, and then by extension taking it upon ourselves as one of the terms of references for the committee's output to overhaul these two statutes is no mean task. And let me tell you, we have traversed this country. We have been able to get views from themselves as parliamentarians, from all stakeholders in the criminal justice systems, consequent to which we have been able to compile this piece of work. And therefore, we are happy to engage the Republic of Kenya to tell them exactly why we want to overhaul these two statutes. And we have, let me just now give the basic background. Yeah, we have the 2010 Constitution, which is quite progressive in nature. So if we do not progress other statutes to align with the progressive Constitution, then we are doing zero work. Starting with the Penal Code, as colonial as it were, it uses very derogatory words, particularly for persons who are sick with psychosocial, intellectual, and mental disorders, such words as imbecile, idiots, insane person. And, you know, people do not know that persons who have mental disorders, who have intellectual and psychosocial disabilities, are sick people wanting treatment. What about persons who attempt to commit suicide, Latif? These are also persons who are sick. Really, do you need such a penal offense in our statutes? No. So we need to divert these persons elsewhere, where they can get treatment, where they can get counseling, and other kind of support. We also have other provisions that we need to amend, for instance, to decriminalize and reclassify petty offenses. What happened before the formation of our committee is that a study was carried out by the National Council on Administration of Justice, conjunctively with the Legal Resources Foundation and the Resource-Oriented Development Initiative, RODI, where they found that the justice system is biased against the poor. And I think that is not an understatement. It's a fact, Latif. So much so that those persons who are poor, they are charged, they find their way into jails. As a result, our jails are congested up to 70% by petty offenders. So what can we do as a committee and to help this nation so that we reverse this situation? So we have proposed to delete the petty offenses that are provided for under the Penal Code. Delete them.
What does that mean?
Delete them is to remove them, so that petty offenders, the very minor petty offenders, you know, I think we need another session for us to define what petty offense is. But we have very minor petty offenses like falling the air, insulting, going on the streets for purposes of prostitution, minor trading on the streets. You know, we want to remove them from the main penal statutes. But that is not to say there is no justifiable cause to punish such persons. Otherwise, we would have a lawless society. As a result, we have proposed ways of punishing them, diverting them. You know, you can give a warning, you can give them community service, you can put them under probation, you can ask them to sign a commitment to keep peace, etc., etc.
So we are not decriminalizing.
We are decriminalizing. To decriminalize, Latif, just means that you remove such petty offenses from the main penal statute, so that they do not have to go before a magistrate, take those pleas, and they are taken to jail. And even if that were to happen, they do not have to be placed under custody sentence. Simple as that. So it is a big debate, and I think we go on. I can stop at that so that I can see Ms. Du wants to say something.
I want to ask a question. Maybe we can take a few steps back, because the Penal Code, at its earliest, what is it meant to do? Because now we are saying, let's make some changes to it, but a code, obviously, is something that you then go by, right? So what was it originally established to do?
It's a very simple answer. Penal Code, what is penal? It's an offense. What is penal? It is to punish. So Penal Code provides for offenses that are punishable by law. And that is why we have the code. The code is what spells out what offenses are punishable and by what sentence. As simple as that. Then we have the Criminal Procedure Code. The Criminal Procedure Code, as the word procedure provides, is a process. What is the process of effectuating the Penal Code? As simple as that. So we have the offense statute and the manner in which we punish those offenses. And then we have the procedural statute, the procedures through which we effect the Penal Code. It's as simple as that. I hope that is simple.
And those two go hand in hand.
Those two go hand in hand, but they must not necessarily work conjunctively, because if you are charged, for instance, or an offense of stealing under Section 275 of the Penal Code, it does not mean that I must necessarily have to refer to the CPC, that is the Criminal Procedure Code, to know how to punish you. Yeah.
You know, if what you've just said only required a little knowledge of the English language and understanding what is being said, then I would agree with you.
Yes.
They are simple. But when you then involve the human person in their various capacities and you want to actualize it, then there's nothing simple about it.
True.
Because then the individual comes with their wherewithal and with their own understanding and with their own biases.
Yeah.
Yes, it provides a guide, it provides a platform, it provides a structure within which one can work. But the thing that I find perhaps most disturbing is, even when it's as clear as you're stating it, internalizing it so that it is actually used to achieve the purposes for which it was intended. And in the case that you have here, that's amidst the baggage of this penal code that you're trying to repeal. Because that is what has formed the mindset of those who are in the justice system.
It is very true. Thank you very much. It is very simple, and that is why we want to reform this criminal justice system, because we have the code. That is the Penal Code itself. It is providing for offenses and it's providing for means of punishment for those offenses. But clearly, when we come now to the justice sector, that is the adjudication process, we find that people are not quite applying it the way it's supposed to be applied. So much so that if you are charged with a smaller offense, that is a minor offense, you, instead of applying an objective mind so that you do not necessarily have to go to jail, those persons are being sentenced to custodial sentences, whereas you have an option of even warning this person. You have an option of placing this person under a probation. You have this option of even asking the person, please just commit yourself to keep peace and not to commit an offense. Yeah. That is it. But incidentally, you find that the justice sector has this mentality that since you have made an offense, the right way and the proper way and to satisfy the society is just to put you in jail. Yeah. And consequent to which I will just apply the custodial sentence. That is why now we find our own jails are full of these petty offenders. So really the sensitization is very important, one. Number two is that for a person to just get to court or where you are working from to see the Penal Code and to see an offense provided for becomes the eye catcher that this is what I'm supposed to apply. And therefore, Mr. Latif, if we remove it from a statute that is always on your table on a daily basis, then you have no basis to do what you ought not to do. And you have the basis to do what is right. As simple as that.
We've actually had very many conversations on this show about petty offenders and the petty offenders, and looking at the injustice that's meted out on people just because you were caught, I don't know, throwing garbage somewhere, and you're taken to court, and the judicial officer sentences you, first of all puts you in remand, let a 20,000 shillings bond or bail. And it just, you can see it's impossible for this person to raise that kind of bond or bail. And we've been raising this issue. So this is something that has been there for a long time. So of course, reforms in this sector are absolutely what we need. However, and I want to come to you, Wakili, as legislator and also as a lawyer. It's taken us so long to actually get to this point where we are reforming and reviewing the penal code and the criminal procedure codes. That means that we need to have some change of behavior and change of our own understanding as jurists, because all the jurists before you have just been applying this. And, you know, they always argue, you know what, the criminal procedure code restricts me from thinking beyond this and applying my humanity and looking at this. And then we, the citizens, don't really understand the penal code, this and the other. We just hear police telling us, penal code, 252 penal code. We hear lawyers saying, oh,
according to the penal
we don't
code.
understand. Now it's come before you, and you have to come and consult us as you now look at whether this should actually pass into law. How are you going to sensitize the public so that we can all feel that, yes, everything that the NCAJ has actually, and the committee that's led by Justice Ngenya has been working on, is comprehensive and will bring justice to us, the citizens?
Thank you. Trying to put this issue on what you call digestible pieces. Because sometimes we might be too legalist and we lose our audience. This is a process of, number one, breathing life to our new constitution. And maybe just to answer your question on the timing, is breathing life under the new constitution to comply, in particular, on the Bill of Rights. And number two is to relook again, because if this bill, the penal code came up in 1930, so you talk about close about 78 years, and therefore it was not meant for the common Kenyans who are walking on our streets. It was meant as a law which was built up by a colonial master against.
It was to control
the colonial, against his subjects. And that's why you find, even in terms of definition of certain terms, imbecile, idiots, you find it in our current penal code. So, and that's why I'm very proud that this proposal will first and foremost resonate very well with the common man, because as Judge Mapio has said, the petty offenses predominantly affect the underprivileged, not because they are criminals, but by the state of the economic status. That's why they find themselves in the wrong place at the wrong time. And therefore, yes, I want to agree with her that it is timely, and it's addressing the common man, from the language to also from the language, the language of the penal code, and the penal code is a law like any other. But to use the word code, code is an arrangement of things. Is civil procedure code, penal code. Penal code is just you can even call it criminal law, criminal act, just to make it much easier. Number two, you will find that because this law was predominantly made by the colonialists to rule against subjects, it does not serve the 21st century in terms of the current way of doing this. Do you know, my good people, that hawking was a criminal offense under the old penal code? Is actually currently hawking, and hawking is basically a petty trader selling jugukaranga, selling sweets on the streets, selling handkerchief. That's a criminal offense. Do you also know that falling the air is a criminal offense? Yes. You know, cities look at me surprised. Yes, falling the air, because during the colonial times, if you go to in Mzungu, I think the Mzungu was expecting is only the blacks who can fall the air, and it became a criminal offense. And those are the things we're talking about. Let's also point out, do you know that there is no criminality in prostitution. The crime is earning from prostitution. And that's why there's another funny law called loitering without a purpose. Because if then there is no a crime called prostitution, and the crime which arises from it is if you benefit from the income of prostitution, then they may have to look for a way of ensuring they catch you, because how do you prove that I make a living through money obtained from prostitution? It's shambolic. And therefore that's why they brought in that petty law called loitering without a purpose. And I'll tell you this. If you go to our coast today, and I'm very, very happy that we are at this juncture. Today, if you go to our courts in Kibera, Makadara, in our normal law courts on a Monday, you spend about almost 7-8 hours, and the crimes you hear is a crime of vagabond, crime of loitering without a purpose, drunk and disorderly, all manner of things. And I think where I'm as a legislator, where I think that where the rubber meets the road is that we are addressing repressive laws which affect the common man each and every day. And that's why I'm very hopeful and very optimistic that this law will see the light of the day in the floor of the House, because we'll be talking to the people, because that's the kind of complaints we get each and every day. And you said it, where we also need to look into is on the area of punishment. Does it mean that every petty offense that one has to go to jail?
There's something I want to ask.
Let's take a break. Let's take a break.
Yeah.
All right, let's take a break.
26 minutes to 8. We're having a conversation about review of the penal and criminal procedure codes to align with the Constitution of Kenya 2010. Our guest in the studio this morning, the Honorable Lady Justice Grace Ngenya, Judge of the Court of Appeal and Chair of the NCAJ Committee on Criminal Justice Reforms, and the Honorable Wakili Edward Mureu. He is a Gatanga MP and a member of the National Assembly's Justice and Legal Affairs Committee. Keep it here for more. Good morning.
This is the situation.